Well, good evening, ladies and gentlemen. We would like to welcome all of you here tonight. We have a wonderful and full house for this great event this evening. My name is David Pryor, and in behalf of my colleague, Dr. Tom Bruce, we're saying that this is our very first public forum. We're going to have a lot of them, but I don't think we'll have any with dignitaries quite like we have tonight. This is going to be hard to surpass in the future. But we're truly honored that you would come tonight for this event. This event tonight is being sponsored by the University of Arkansas Clinton School of Public Service, by the William Jefferson Clinton Foundation. And Stephanie, we thank you for your wonderful support here. By David Alsabrook, who is director of the Clinton Library here in Little Rock now, after all of these years. Thank you, David, and thank you for your cooperation, you and your staff. And many, many others out in this audience and across this state and across this country who have made this event possible. The program tonight was the brainchild, if I might say, of a remarkable young man by the name of Ryan Ripple. Since February, Ryan has been a superhero on our staff, and very, very sad to say that in 3 weeks, Ryan will be leaving us for Cambridge, England, in pursuit of his advanced degree. His association with the Clinton School has lifted our spirits, has inspired all of us to do better. Ryan, we want to thank you tonight. We want to wish you well and wish you Godspeed. I don't know how we're going. We may close the school down now. I also want to recognize the president of Miles College. And I believe, if I'm not mistaken, there's a delegation from Miles College, and I'm not quite sure where they are. Dr. Albert J.H. Sloan. Dr. Sloan and your delegation from Birmingham, Alabama. Thank you. What a great history during the Civil Rights Movement that Miles College in Birmingham, Alabama, became one of those very rare places where people could get together and talk about the great problems and challenges that we have. And for you to grace us, Mr. President, and your delegation from the college with your presence tonight, we want you to know we are very, very indebted to you, and we look forward to our visits with you. I know it was not easy to get here. We also want to recognize the members of the federal judiciary. Please, if you would, those federal judges who are here tonight with us, if you past and present, I might say, if we have any past federal judges, I don't think there is such a thing. But anyway, we want you to stand up and be recognized. Judge Hendren and Judge Wilson, Judge Moody, and Judge Isley, Judge Holmes, Judge Howard. Certainly means a lot for you to be here. I think that Patrick Henry Hayes, our mayor of North Little Rock, I believe is here. I'm not sure. And possibly Jim Daly, the mayor of Little Rock. If they're not, they may be on their way. They were scheduled to be here. I know they have a lot of things doing. A special bouquet tonight we would like to throw out, and they've had a lot of bouquets this week, but there's not enough that we can properly thank them with. The very courageous, the very wonderful and inspiring Little Rock Nine, the true heroes of our educational system. This is pretty emotional. I don't know if it is for you, but it is for me. Another special welcome. Now, I get emotional about this. Let me take this opportunity to introduce you at this time. This is sort of an official introduction of this group of 16 young men and women who have given up their professions, their vocations, their jobs, their health insurance, their families, everything, in order to come to Little Rock, Arkansas, to this very unique school, a school of public service. They comprised the Clinton School's very first inaugural class. And they came here not for money. They came here to make a difference. If I could, I would like for the inaugural class to stand, if they would. Please, if the 16 of you, if you would stand. And I'm going to call your name. Thank you. Just so our citizenry will get a general idea, Joe, where y'all are from, let me very quickly call your names. I'm not going to ask you to say anything tonight. I usually do, so they'll know where you're from and what you look like. Joe Ballard, Kansas City. Joe, right here. We appreciate it. Jean-Pierre Beckelot of Cameroon. Scott Curran of Chicago, who just got married Saturday and is back in school Monday. Vivian Flowers of Pine Bluff, one of our very own. Malcolm Glover of Bowie, Maryland. Malcolm Glover. Erica Hall of Ledyard, Connecticut. Amber Holloway, Austin, Texas, but grew up in Rogers, Arkansas. Greg Holyfield of Nashville, Tennessee. Dawn J. Cox, Vermilion, South Dakota. Gervis Kalola, Tanzania. Thank you, Gervis. Erica Lawler, Westfield, Massachusetts. Nancy Mancia, San Diego, California. David Morrissey, Overbrook, Kansas. Elisa Rosales, Lincoln, Nebraska. Catherine Snodgrass of Oxford, Mississippi. And John Spears of Fort Smith. We're proud that you're here. Let's give them another big round. Thank you. This is truly really a historic night for the Clinton School and the Clinton Library. It's fitting that our very first public forum is going to be about Brown versus Board of Education. This is a case, you'll be hearing a lot about it for the next hour and a half, that redefined America's flawed conception of equal treatment and ultimately transformed the very social fabric of our own community, not only in Little Rock, Arkansas, but across this country as well. Our students begin this new semester, this new school, by reconnecting with true heroes of our nation's educational system, like the Little Rock Nine, like Judge Robert L. Carter, who at age 88 from New York has come to be with us for this event. He is responsible for the legal strategy behind the Brown case. And Professor Charles Ogletree of the Harvard Law School. As these 16 young people blaze the new paths in public service that they will be pursuing, they do so on the shoulders of these great giants who have gone before them. It was June in 1966 when Robert Kennedy traveled to South Africa to speak to the world about the evils of racism and oppression. He challenged that crowd in South Africa of students at the University of Cape Town to embrace their capacity, their responsibility as agents of change. He challenged them to turn away from the old barriers of hatred and fear and instead look to new frontiers of unity and hope. He believed that their optimism of the young people would be the energy that could truly change the world. I quote Robert Kennedy, "This world demands the qualities of youth, not a time of life, but a state of mind, the temper of the will, a quality of imagination, a predominance of courage over timidity, the appetite for adventure over the life of ease," unquote. Our guests tonight and our student body at the Clinton School, they exhibit these same qualities of youth. They're courageous, imaginative, and committed to finding answers to our society's greatest challenges. We welcome you. We welcome our community to this campus for our inaugural event. This school is truly your school. We hope that you're as proud of it as we are, as our inaugural class and our inaugural faculty and staff are here with us tonight to give this a great kickoff. We hope you will help us to translate these big ideas of the classroom into ultimate good works around our state, around our nation, and ultimately around the world. I hope that you will please allow me tonight to present to you our moderator, the very distinguished John DiPippa, Associate Dean for Academic Affairs and Distinguished Professor of Law and Public Policy, the William H. Bowen School of Law, University of Arkansas in Little Rock. A member of the UALR faculty since 1983, John teaches constitutional law, the legal profession, law and religion, and dispute resolution. He is also an inaugural professor of the Clinton School of Public Service. We're proud to have him. Thank you very much, Dean Goldner, for allowing us to have John DiPippa here. He is truly one of our outstanding leading legal minds in the state of Arkansas, and to have him on our campus to share his knowledge and his wisdom with our inaugural class is truly a wonderful opportunity. He is a graduate of Westchester University, Washington and Lee University School of Law, where he was named to Order of the Coif. Ladies and gentlemen, John DiPippa. John? I can go around here.
It's really my pleasure to be here, and it's always wonderful to be introduced by David Pryor because he makes me feel like I'd like to know that person that he's been talking about. And I cautioned him not to use too many adjectives tonight because apparently he gets in trouble when he does that, but he has my permission to use adjectives as much as he wants, but especially when he talks about the Clinton School and our speakers tonight. And it really is my honor to be in this position. It was certainly my honor to be part of the first class with this wonderful group of students. And it's my particular honor tonight to introduce our speakers because our country would not be the way it is today without them. And there's no question about that. So you don't want to hear from me. Let me take a few minutes, though, to tell you about these wonderful people in front of you. Judge Robert Carter's story is not so well known as some other lawyers of the civil rights era, but without a doubt he was crucial to the success not only of Brown versus Board of Education, but a number of other milestones of civil rights jurisprudence. Judge Carter was born in Caryville, Florida, but grew up in Newark, New Jersey. He excelled academically and graduated from high school at the age of 16. He went on to earn a degree in political science from Lincoln University in Pennsylvania. He earned a law degree from Howard University Law School and a Master's of Law from Columbia University, and was in the process of pursuing a doctorate when other events took hold, like the struggle for civil rights. Judge Carter entered the service in 1941, and the virulent racism that visited upon him and others during that period gave him what he called a fierce determination, a zealousness to fight racism with all my intellectual and physical strength. In 1944, he accepted a job on the legal staff of the NAACP. He became the NAACP's general counsel in 1956 when it and the Legal Defense Fund became separate entities. He remained in that position until 1968. During the period of his service at the NAACP, Judge Carter argued 22 cases before the United States Supreme Court, winning 21 of them. Judge Carter's vision, skills, and intellect crafted the legal arguments that toppled segregation. He persuaded his colleagues in the Brown case to use social science data to document the harm segregation caused young children. At the same time, his legal research and analysis expanded the understanding of equality until it could no longer support segregation. Judge Carter argued one of the cases that was joined in the Brown versus Board of Education decision, but he also successfully defended the NAACP in a series of cases thereafter in which Southern states attempted to discredit and humiliate and intimidate and destroy the organization. In the process, he helped establish bedrock free speech principles that today safeguard the rights of individuals and groups to advocate for social and political change without fear of government retribution. In 1968, he left the NAACP in protest over the firing of a member of his legal staff and joined a commercial law firm in New York City. In 1972, he was appointed as a judge to the United States District for the Southern United States Court for the Southern District of New York. He has received honorary degrees from Yale and Harvard, as well as the Federal Bar Council's Medal for Outstanding Public Service. In 2005, he published his memoir, A Matter of Law, a memoir of struggle in the cause of equal rights. Charles Ogletree is the Jesse Clemenko Professor of Law and the founding director of the Charles Hamilton Houston Institute for Race and Justice at Harvard Law School. Professor Ogletree is a native of California, although he has Arkansas connections. His grandparents were born in Arkansas. He received his undergraduate degree from Stanford and his law degree from Harvard. After graduation from law school, Professor Ogletree took a position with the District of Columbia's Public Defender Service, perhaps the preeminent public defender in the country. In 1989, he joined the Harvard faculty. Professor Ogletree has a long history of involvement in important social issues going back to his days at Stanford. During the late 1980s, he assisted Anita Hill in her testimony before the Senate Judiciary Committee during Clarence Thomas's confirmation hearings. He is an important and prolific legal theorist and civil rights scholar. Among his publications is the award-winning book, Beyond the Rodney King Story, an investigation of police misconduct in minority communities. He has written extensively about the 1921 Tulsa reparations case, a case on which he continues to work. In 2000, he was named one of the 100 most influential lawyers in America by the National Law Review. And in 2003, he was named one of the 100 most influential blacks in America by Savoy magazine. Black Enterprise magazine also named him one of the legal legends among American black lawyers. In 2004, he published his memoir entitled All Deliberate Speed, Reflections on the First Half Century of Brown versus Board of Education. Professor Ogletree.
Thank you so much, Professor, for that generous introduction for me and Judge Carter. I'm going to take 5 minutes to give a broad outline of the issues for today, and then Judge Carter will make some brief remarks, and then we'll take questions from Professor DiPippa and then from the audience. I spent the first half of my life in Merced, California. That's where I was born, in the Central Valley, and the second half until now in Cambridge, Massachusetts. And I have this ironic situation where both California and Massachusetts claim me. Well, that's not exactly true because I'm so controversial. Massachusetts claims I'm from California. California claims I'm from Massachusetts. But I say that to say that this is a bittersweet moment for me being here in this Clinton Library the day after we unveiled the statute of the Little Rock Nine, because I do have roots in this state. My grandfather and grandmother were born here in the late 1800s and early 1900s in Texarkana and Ozanne, Arkansas, respectively. And my mother was born here. She said in Little Rock, she claimed Little Rock until a few years before her death, and she said it was near Little Rock, or within the same 300-mile radius of Little Rock. So it's an area called Pop Spurs. No one has been able to tell me where that is, not even our great friend Senator Pryor, but somebody might know about Pop Spurs before I leave Arkansas. But it's a bittersweet moment for me because the Arkansas that we are witnessing today and that we witnessed yesterday is not the one that they were born in and raised in. And one of the telling signs of the struggle for equal justice, as Judge Carter talks about in his book, is the fact that my grandparents left here because they couldn't see a life as African Americans in Arkansas, and they fled to California looking for something different. And my mother started here in 1933 when she was born, and started here in public schools in the late 30s. And none of them ever came back. And they never really talked to me about it in a way that connected, because they didn't complain about it, they just didn't talk about it. And I know it was significant because I know that as adults, when they were in Arkansas, and even when they first went to California, they never voted, because that wasn't something that African Americans did. They didn't have a formal education. None of them went beyond elementary school, and my mother only made it to the 10th grade. And so they had a different existence. And I say all that to say that I'm grateful to them for not being bitter about their experiences and not spoiling my experience, but always motivating me to learn, to teach, to not look back, but to always try to move forward. And so I say today, as Judge Carter and I are here on this forum, thank you, Little Rock 9. I was 5 years old when you took that courageous step. And it means so much to me now that people went through the screams and the taunts and the attacks to get an education. And I'm living in California where we didn't have to confront that, but you set the parameters for what it was all about. And I say people like Rodney Slater and Lottie Shackelford and former governor and senator and now Dean Pryor, Judge Howard, who's here, who litigated cases with Robert Carter here at an important time in our country's history. Those are the people who have made such an important difference and made it possible for us to be here today, and I'm forever grateful. And for me, I wanted to say three things, and then I want to turn it over, and that is that this book I wrote, All Deliberate Speed, Reflections on the First Half Century of Brown versus Board of Education, is a meditation on where we've been, where we are, and where we need to go. And I write it in that sort of personal voice because I know that I am what I am today, not because of any intrinsic value that I have. I went to a Stanford and graduated Phi Beta Kappa. I am a tenured member of the Harvard Law School faculty, not because of any excellence on my part, but because a group of women and men, largely African American, most of them educated at HBCUs, in particular Howard Law School, had a vision more than 50 years ago. And so I'm one of those who are the beneficiaries, and every time I speak and everywhere I go, I say, thank you, Brown lawyers, for opening the doors for me. I shall never forget it, and make sure that wherever we go, it will always be known that you did it. And they did it in a unique way, as I talk about in the book. They opened doors to places for people like me where they could not enter. That is, that Thurgood Marshall couldn't go to a Stanford or a Harvard. Robert Carter couldn't go to a Stanford or a Harvard at that time. But they opened up the doors for my generation, and we have to be thankful. Many of us think we made it on our own, but I know there have always been bright and incisive and thoughtful people of color and women, but they've never had the opportunity. And every time each of us look at the success we've had, we have to thank those who laid down and sacrificed their own success to make it possible for us. Two other brief things to put this in context. One is about the Brown case. When we read that case, we don't appreciate the complexity of our history of race relations. Because we read the case now as constitutional lawyers, we talk about Chief Justice Earl Warren, who brought the court together for 2 unanimous decisions. We talk about the court issuing a unanimous decision, but what we forget are some of the ingredients that made it happen. And as we think about the Little Rock 9, we have to be very grateful to those families, including young people who put their lives at risk to let lawyers defend them in courts when they had to go back to those neighborhoods and go through all of the grief that they experienced. And two people in particular are footnotes in history, and I hope that we can elevate them, and I'm trying to do that. One is Robert Carter. He is not just a lawyer in the Brown case. He found the clients. He went back to places like Topeka and South Carolina. He went in those courthouses. He argued those cases before judges, winning and losing, and took them all the way to the Supreme Court. He didn't just show up in Washington and say, let's argue Brown, right? He did the groundwork, and that's what it takes. And he argued more of the cases than any other lawyer in the Brown cases. A second person who's not here, who is one of my true heroes who I never, ever met, and his name is Charles Hamilton Houston, perhaps the greatest lawyer America has ever known, and a lawyer that few Americans even know. This Saturday, September 3rd, marks Charles Hamilton Houston's 110th birthday. He was born September 3rd, 1895, African-American, Washington, D.C. He went to the M Street School in Washington, now Dunbar High School. He went to Amherst, where he was valedictorian. He went to Harvard Law School and was the top of his class in the 1920s, the best student there, African-American, but he couldn't get a job because of his race. He didn't get mad, he got even. He left Harvard, went to Washington, D.C., and made Howard Law School a civil rights laboratory to change the law. He trained Thurgood Marshall. He trained 98-year-old Oliver Hill, who's still alive, one of his students. He trained Spotswood Robinson and so many lawyers. And he had a very simple slogan. It was called, "A lawyer is either a social engineer or a parasite." You had to make a choice. Either you're going to use your skills to lift up your community, or you can be a disease in that very community by being selfish and not concerned about the larger concerns of that community. And I'm opening 2 weeks from tomorrow at Harvard Law School, the Charles Hamilton Houston Institute for Race and Justice. It's on my website, it's alldeliberateSpeed.com. I'm bringing back every single one of the living lawyers who worked on the Brown case: Judge Carter, Constable Baker Motley, Bill Coleman, Jack Greenberg, Lewis Pollock, Oliver Hill. All those lawyers are coming back to tell their story about Oliver Hill. I'm bringing back Charles Hamilton Houston's family. We're going to have a major presentation. My dear friend Cornel West, who's no longer at Harvard University, is at Princeton. I said, Cornel, I'm going to give you the title of your talk and you take it from there. And the title of this talk is Social Engineers or Parasites. That's it. And if you know Cornel West, you can expect what that will lead to. And it's all webcast as well, so you'll be able to go to the website and see it if you can't be there. The final thing I want to say is that the book talks about, and we're talking about two Browns. The Brown decision that was written on May 17th, 1954, that we celebrate because it was unimpeachable. It was a unanimous decision upholding the right of all children to a quality education. That's the one we celebrate. A year later, many of us forget there was a second decision that took away the force and effect of Brown 1, and that was Brown 2. On May 31st, 1955, the same Supreme Court, again unanimous, talked about the remedy in Brown and said that we are ordering the lower courts to implement such orders and decrees as we have decided, and to do so with all deliberate speed. Those three words, all deliberate speed, took away the force and effect of the most historic decision the court has ever issued on the issue of race. Because we know it was all deliberate speed, which meant no speed at all. And that's exactly what happened. Brown was decided in 1954, and the resistance started right then. And it's amazing, if we look 50 years from Brown in 1954, we still see all deliberate speed with no speed at all. Now, I don't know if this tape's going to be in the Clinton Library. I hate to say this about my dear friend Bill Clinton, but I have to say this. One of the first things Bill Clinton said in 1993 when he was elected, he said, and I'm going to make sure that we eliminate the policy of discrimination against homosexuals in the military, and we're going to do so with all deliberate speed. And it was with all deliberate speed because it never happened. That's not what he intended, but the whole idea is that we find ourselves 50 years after Brown, as we commemorate that decision, we find our schools more segregated in some places in 2005 than they were in 1955. We find, accelerate levels of dropouts of African Americans and Hispanics in high school. 30, 40, and 50% in some urban areas from California to New York. It's not a Southern problem. And the final thing I want to say to this Arkansas audience to make it clear is that we should never understand the problem of discrimination and of segregation as a Southern problem. It was a national problem that we tried to define as a Southern problem. When I say that, these lawyers didn't bring a lawsuit just in South Carolina. They brought one in Topeka, Kansas. They didn't bring it just in Virginia. They brought it in Wilmington, Delaware. They knew the problem was a national problem, and they had that sort of vision. And so the South should stop taking a beating for being the problem. The problem was a national problem. And Dr. King reminded us he had more objections in Detroit and Chicago and more violence than he did in Mississippi and Arkansas and other places. And so the final point is that as we celebrate the Little Rock Nine, as we celebrate this magnificent library, as we celebrate where we are in the 21st century, I take my hat off to somebody who was there, who found Dr. Clement Clark, who convinced Thurgood Marshall what should be the arguments, who won 21 out of 22 cases. The one case he didn't win, probably African American men who were innocent of rape and who were executed. Even though Judge Carter had argued this case before the Supreme Court, the one case that he lost was not a case that should have been lost on the merits. That's what you call a genius. And I'm so glad to be a mentor and a friend of the person you've come to hear tonight, Judge Robert Carter.
I was in Little Rock when the 9 children were dodging the mobs and had to be escorted into the schools. I was in Little Rock during that year, and I was in Daisy Bates' home, and we had to be guarded by the public. The black community had guards around with guns to be sure that we were not harmed. I was in Little Rock, and I was in Judge Easley's court. I didn't fare too well then. But apparently, I look at Little Rock now and I see what a vast change has come. Is the change real or marginal? This is a country that has been committed to white dominance and black subordination. It is a country that is committed to white supremacy. It's a country that feels that blacks or people of color should have less than whites. It is a country, indeed, that feels that the white skin is sacrosanct and provides people with greater things than people with skins of color. And yet, the decision that is considered at the pinnacle of the jurisprudence in this country is a decision that was created by black legal skills black creativity and black intellect. Brown versus the Board of Education is a creation of black skills, black lawyers. There were some white lawyers, but not involved in the creation. Jack Greenberg, for example, was involved, but I took Jack Greenberg on his first trial, and his first trial was Brown versus the Board of Education in Topeka. He had nothing to do with the creation of the ideas that led to Brown. One of the other people that was involved in it was Lou Pollack. When we talked about the issue of using the social science evidence in order to go with it with the Supreme Court, Lou felt that was not a good idea. Very recently, he publicly apologized to me for that. I'm not saying this in order to, be chauvinistic or anything like that. What I am saying is that here in this country, when blacks who are a subordinate group have created a decision that the country regards as one of its greatest that has been produced. It seems to me that that's an evidence of the greatness of this country. We ought to be proud of that. We ought to, I'm not sure that the public is aware of the fact that Brown's creation is a black deal. The lawyers and around are, but not generally in the public. But it should be something that should be touted out in the public. The public ought to know about it. The public ought to be proud of it. There is no other country in the world where the subordinate group has been produced something that the country says is one of the greatest things ever. No country in the world, other than the United States. And so, my view is that this shows the country's greatness, its potential for doing even greater things in diversity. And with the knowledge that a subordinate group, there's enough looseness in the joints of the white supremacists in this country, so that a subordinate group comes and creates something that the country adopts as being the greatest thing. To me, this means it should be shouted to the world. I know no other country where this could happen. And I think it's something that we ought to be proud of. It's something that shows our potential to become even greater, to develop even greater with diversity as time goes by, and as we begin to lose the grip of white supremacy and begin to understand that people of color has nothing to do with talent. So I think that's all I have to say. There's nothing more to say.
There you go. So I managed to steal Judge Carter's mic. That's a good way to start off the question and answer period. I want to ask Judge Carter something because I heard him talk this morning and then I heard him talk again. And it really is about the freedom and the opportunity you had to really challenge the legal concepts and really expand them. And I'd like you to talk about what it was like to be able to do that in the environment leading up to Brown.
Well, I was pushed to, I think the word is to think outside the box. And Thurgood was my boss, and he pushed me, wanted me to push on the edges of the law, encouraged me to do that. And of course, I could think and do these wild things that would, because of the fact that if it turned out not to be a good idea, Thurgood took it on his shoulders, not mine. And that was why, as a matter of fact, that I could do it, because he was out there, he was taking the responsibility. Fortunately, the ideas were good. And after a while, I began to shape. I wanted to have some credit for these ideas myself. But that's how you develop, I think, in terms of things. A young man, don't try a student, usually can't be out and try to create and so forth and so on things if it's going to fall on his shoulders. That's too heavy a burden. But if his boss takes it, then he's free.
Judge Carter, also with your decision on the social science data, some stories say that was a hard sell. It was difficult to convince your colleagues to use that data.
Yeah.
Was it as hard as some people make it out to be?
Well, it was a very hard data, a very hard sell, because so many of my colleagues thought that it wasn't hard science. It was, you have to know this was years ago, and social science did not have the respectability that it has now. And so they were telling me, this is not hard science, this is nonsense. And my poor Kenneth Clark, they gave him such a hard time. But when we were faced with it and they were challenging, and I said to them, you got anything else? And so they said, nobody said anything. I said, well, you got anything else? I'm going with this.
Professor Ogletree, you talked about the second Brown decision, and you take the title of your book from that unfortunate phrase, all deliberate speed. In our class last week, we talked about the current state of not just education, but what's going on now in the sort of wake of Brown. What could we do, we being this country and people who are interested, to maybe reverse that tide and reformulate this notion of Brown and the energy that came from it?
There are two things that I would mention. First is the problem that we have in America today, and I would simply describe it as racial fatigue. That is that America has reached the point where there is not a lot of, there's impatience with discussing issues concerning race. We've been there, we've done that, everything's fixed now. Why do we need this all over again? All the laws are changed. Look at Condoleezza Rice and Colin Powell. You know, you got Bill Clinton, the black president. Why are we still having issues about race, right? So there's this racial fatigue where people just don't want to talk about it. In fact, I actually had a conversation with President Clinton about this when he had the One America initiative, because I wrote an op-ed about it saying, this is very important, but be careful in what you do, because you don't want to ask Black America, what's wrong with Black America, unless you're prepared to fix it. You don't want to start surgery and not be prepared to complete it. And I think the president got wind of that in some sense, and so there never was a set of public recommendations how there were some soft, important things said, but the idea of really talking honestly about how we feel, we didn't get there. So one is racial fatigue, but on the other hand, what we need now, I think, is the antidote to racial fatigue is dialogue, and I mean dialogue. I have heard in the last 2 days I've been here that those students who were at Central High in 1957 are still bitter because they believe they've been misunderstood in terms of what they stood for and what they were attempting to do and their view about how integration should have occurred. I don't know whether that argument's right or not, but it seems to me that we can't have closure with the Little Rock Nine until there's a dialogue with everybody. It can't just be the Little Rock Nine that's coming to the table. We have to have those students who are shouting and screaming to hear that dialogue. And you can't have a monologue. You can't have two conversations going another direction. I would love to see, I would volunteer to moderate a panel September 2007. I'm putting it out there right now, between people to hear what people were thinking then and where they are now, because I think until we deal with that pink elephant in the room, we're only going to have partial progress and only symbolic victory, because we won't be able to talk about what really might have been underlying those issues. So that's part of it. The other problem is that we have a major problem in our own community where our young people have never been taught in public schools, whether teachers are black or white, about this movement. And I've heard from many white educators, they don't teach it because it's uncomfortable, it's confrontational, it's emotional. I don't know how to do it in a way to explain why people were protesting. I can explain the dogs, I can explain the bullwhips, I can explain that, and therefore I don't talk about it. The problem is that we have a generation, 2 generations of African American and Hispanic and other children who have no idea what it meant to have to drink water from a colored-only fountain, who had no idea that you couldn't use public facilities like a restroom unless they were designated by race, who had no idea what it meant to sit in the back of the bus. Now, I say that because I grew up in California in an integrated society, but I lived in South Merced, African American, a few Hispanics, no whites, North Merced, all the whites. And it's ironic that in my generation, as I grew up, I looked forward to riding in the back of the bus. That was a cool place. I didn't know that it was segregation. For me, it was a wide seat in the back of the bus, right? When I went to the theater, I wanted to be upstairs in the theater, right? Because we could throw jujubes down at people and popcorn. It never occurred to me that that was where coloreds had to go and whites were sitting down. I liked the view upstairs. So since I didn't learn it in the 50s and the 60s, imagine those children born in the 70s, 80s, and 90s. Our children, other than those in the juvenile justice system, have never been arrested. That's good. But being arrested in the 30s, 40s, and 50s, and 60s was a badge of courage and honor. It meant you stood for something, right? And so we have not been able to transform what was an integrated, multiracial, multigender, multi-religious movement from the 50s and 60s to where we are now. And so my sense is that we need to go forward to the past. That is to go back to that old thing, neighbor to neighbor, and go to our churches and synagogues and temples. But we need to have a dialogue, a real dialogue, to be upset, to be mad, to want to walk out, but to come back and say, okay, I've taken your best punch, and now I'm prepared to have a real dialogue about going forward. So my sense is that we can do it. We have to do it. The final thing I'll say is this, is that every time we have these forums, the young African American women and men always come up and say to me, all right, but where is our Messiah? Dr. King's dead. Who's going to lead us? And I say without hesitation, you're it. You are it. Dr. King was a kid when he took over the movement. Rosa Parks was a kid. Their lawyer, Fred Gray, was a very young lawyer. Judge Frank Johnson was a very young judge. These people weren't 40 and 50. They were young, and they took the extraordinary effort to change America. And my point is that don't look for us. You do it. You, Clinton fellows, you people who are in the community can make a difference, because I think we have become comfortable with certain progress, and I really do think that we need to figure out a way as a community we can have the dialogue, we can get past racial fatigue, and we can push young people who says, I want to be president, I want to be senator, I want to be governor. Yes, you can, and you will be. And your race and your gender and your class will not be a barrier to success and opportunity in the 21st century America. That's what I think we need.
You touched on this in your remarks, and both of you write about this issue in your books, and it's the question of segregation and racial discrimination outside of the South, what the law called de facto segregation, but didn't provide much of a remedy. And Professor Ogletree, you write about it being in Boston during law school, and Judge Carter, you write about the cases you filed to strike down this thing called de facto segregation. I wonder if either or both of you would like to talk a little about that issue, because it seems to me that's part of what you've been saying we need to have a dialogue about. It's not just a Southern problem.
Is this thing working?
Yes.
What is very interesting about that issue is that it is an evidence that the problem of race is a national problem, not a Southern problem. Because after Brown was decided and the whole business was going south and implementing Brown, I found that, you know, I wasn't an old man like I am now. I was a little younger then and feisty. And I found that a little uninteresting. I wanted a challenge. And so I decided to take Brown north to seek to integrate the schools in the northern community, get ideas so that the schools were not 90% black and so forth, and get them integrated with various ideas. So we started north, and all these people who had been going south and talking about how we had to do things in the South, when we came up north, they didn't want us there. They had no desire to have their schools integrated. They had no desire. They fought, and every bit of the way, bitterly. There wasn't, as a matter of fact, there wasn't one point even violence. I think I was in Boston, wasn't it? And maybe in a few other places. But what it shows you is these northern people were saying, okay, you can, you know, integrate, but not in my community. And I think that what we all understand and forget, Northerners are also saying, you know, Northerners were saying, well, you know, there are not many blacks in my community, so I can't be prejudiced. But of course, that they haven't had the experience of having blacks, and they're probably the most prejudiced people around, because they haven't at least faced that fact at all. So race is a national problem, and the issue has to be attacked on a national basis.
Let me respond by way of an anecdote. I am the luckiest man alive. My wife and I just celebrated on August 9th our 30th anniversary of marriage. And I say I'm the luckiest man alive for this reason. My wife Pam and I both graduated from Stanford University in 1975. And after we graduated, we got married, we were about to head from California to Harvard Law School, where I was going to begin my legal career. And as we were about to leave California for Massachusetts, my wife Pam said, Charles, before we leave, we've got to drive 3,000 miles. Why don't we get a map? And I said, a map? We go out, we make a left, and we drive 3,000 miles. It's not that complicated, Pam. Come on. Well, that's what I said. And of course, we started, and I'm sure this is unique to me, men, but as we would go each day, Pam, at about 8 o'clock, Charles, I'm hungry, can we stop and get something to eat? I said, Pam, we're only 3 hours away from the Capitol. Let's just drive, we'll make it. 5 hours later, Charles, it's midnight, where are we going to sleep? And I said, well, we were right near another state, just give me, and then we could never find a place to sleep because it was too late, they were all sold out. After the third day, I said, Pam, every time we drive in at 1 o'clock, they say no vacancy. I think that's discrimination. She said, no, it's your stubbornness. If we'd stopped at 8 o'clock, we'd have a place to stay. She had called her parents about how to get an annulment on the 5th day, but we'd arrived in Massachusetts. And we were hardly speaking, and as I was heading down Highway 93, some of you know it, we were going getting to Cambridge, and just before we got there, I got lost again. And I called our realtor who had an apartment waiting for us, and I said, look, I'm trying to get to Cambridge, but we're lost. He said, where are you? I said, I don't know, we're lost, right? He said, well, describe your surroundings. I said, well, all I see O'Reilly's Liquors, I see Flanagan's Groceries. He said, get back in the car. I had unwittingly driven in the fall of 1975 into South Boston, Massachusetts, and in the middle of the busing crisis. And here I was. It was at night, which is good, but here in Boston, right outside Cambridge, was a place where black families and children could not go to school because there was white resistance. And the white resistance is complicated. I can't just condemn it. These were white families saying, why are you putting them in the poorest part of Boston? Why not Brookline, and why not Milton and the other wealthy areas? Why are the blacks coming here? But it was still discrimination in 1975. So it told me 21 years after Brown, the idea of integrated education was still an issue that was important. And that really transformed my thinking about this was a national problem, not a Southern problem. And it made me sense that even now our solutions, if you look at the schools in Massachusetts or in Connecticut or in the District of Columbia or in Michigan or in Illinois, they're so segregated now that it sort of defies what Brown was trying to do. And so it tells me that it's not a local problem, it's not a regional problem. That doesn't mean we excuse the South. The South still has some work to do, but it's a national problem that everyone should pay attention to it and try to address it.
I'd like to give members of the audience a chance to ask some questions. I don't get to have all the fun. So we've got some people with microphones, I believe, and if you've got a question, raise your hand and we'll get a microphone to you. Right over here.
Thank you. George French from Miles College in Birmingham. Well, before I ask the question, I did want to point out one of the members of our delegation that's with us is Reverend Dr. Abraham Woods. Dr. Woods is one of the foot soldiers that actually marched with Dr. King and was an architect of the struggle in the South. Dr. Woods is with us as well. Could you, either of the gentlemen, could you all please speak to the composition of the court and how the composition of the court changed in the midst of the litigation of Brown and how that may have influenced the outcome?
Wow, that's a very interesting question about Brown. And when you talk about Birmingham, my father's from Birmingham. He left and never went back either. It's very interesting, and I talk about this in the book, one of the sort of footnotes to Brown. The Brown decision could have been remarkably different if there had not been a major change in the early 1950s. The lawyers had argued the case. It had been submitted. The Chief Justice of the Supreme Court in the early 1950s was Chief Justice Fred Vinson from Kentucky. And the notes of the court now indicate that a majority of the justices, after the arguments, were not prepared to overrule Plessy versus Ferguson. And then something unexpectedly happened, and that is that Chief Justice Vinson died of a heart attack. Now, I don't know about the court's politics, but it's ironic that Felix Frankfurter, who had been a Harvard Law School professor and was on the court, and was not a religious man, but he went to lunch with one of his law clerks after Vinson's death, and Frankfurter said, quote, "This is the first indication I've ever had that there is a God." So something was going on among those justices in that court. Eisenhower appointed Warren, and Warren is complicated as well. As we celebrate the Warren era, all the great liberal decisions, what I discovered and should have known but didn't learn until later in life is that Warren, who put all the other justices together to get a unanimous decision, had also been the governor, but more importantly the attorney general in California, and played a significant role in the internment of thousands, tens of thousands of Asians, Japanese Americans who were not terrorists, who were not combatants. And so I learned in writing this book that as we celebrate Earl Warren, there's a whole community who does not celebrate Earl Warren. In fact, the irony is that Eisenhower later said that the appointment of Earl Warren was the worst damn decision he made as president, even though I think Warren moved the court in a very important direction. But those changes made a difference. Some members of the Brown team have said, oh, it didn't matter, we were going to win anyway. I'd like to hear what Judge Carter says about whether or not Fred Vinson, as Chief Justice, as opposed to Earl Warren, had an impact on the way the court case was decided.
I think we probably would have won, but we would have won by a divided court. And the decision would not have been as important as it is as a unanimous decision. But Vinson certainly was not going to vote for it. About that.
Judge Carter, I want to take you back to another thing you write about in your book, because as we talk about justices, it does signify the importance of the people on the court. You mentioned when you went to the Supreme Court to hear the first argument that you heard in the Supreme Court and Justice McReynolds' action. Could you tell us about that story?
Charles Hampton Houston and McReynolds.
Huh?
Charles Hampton Houston and Justice McReynolds.
No. My first argument I heard in the Supreme Court was an argument in Gaines ex rel versus Canada, in which Charles Houston was arguing the case before the court. And I was in the court, and when Charles Houston got up to argue, Judge McReynolds swirled his chair around and sat with his back to him throughout his argument. The remarkable thing to me as I revisit that incident is I wasn't surprised by it. There was no shock or surprise by anybody in the court. I wasn't surprised, I just looked on it and so forth. Now when I revisit it, I am so annoyed, I am so mad. I am so annoyed with that. There's a story about Judge McReynolds after this case. He had a barber, a black barber, and he wanted to have his hair cut. And he said, well, I just heard this case of the nigger Houston. And so barber went to him in front of him, this is the story, and said that Charles Houston is a very, very good man. He's done a great deal. And we think in the black community that he is one of our best. We think he's eligible and capable of being on the Supreme Court. And if he goes to the Supreme Court, he will represent everybody. And the story goes that as this was going on, the Mike Reynolds was sinking lower and lower in his barber chair. And then as the barber finished, he went back and finished cutting his hair. Now, of course, it's probably not a true story, but I'd like to think it is.
Right over here, please.
I'm Chief Warhorse from Louisiana, came here by force of water. But I'm glad to be here, and the gentleman offered us to come down today. He told me last night he had something to get my mind off of the flood. Excuse me, I'm a little hoarse. But by the way, I was telling him, I'm a national board member of the Southern Christian Leadership Conference. And I see one of my fellow board members stood up over there, foot soldier. So it was meant for us to be here today. As a black Indian, you're talking about racism and coming together. Still in America, people do not know that there are black Indians that exist. And to live in your own country and be discriminated against, it totally hurts. It's an issue that have never been discussed in America. As a black Indian and a national leader, I travel the country with white children, African American, not knowing that they have black Indians in America today, let alone a black woman Indian chief. That is kind of hard, because it's like you're lost in your own country. Yes, the African American have had a lot of problems, and I love that the doctor up there, the judge, keep using the word black. I prefer the word black America over just African American, because then you done put another barrier on me, because my skin say black, but my race is Indian. I didn't pick the name Indian either. Christopher Columbus did that. So we have a lot of correction of education and miseducation. So we must come together to educate. I got here today and saw the Choctaw root. Well, Choctaw is a mispronunciation for Shatta. So when I tell people I'm a Shatta, they say, well, where you come from? That is the proper terminology. I am the chief of the Shatta Nation of the old Florida Territory. And I'm walking on grounds that once was my people's. Normally when it flooded down in Louisiana, hundreds of years ago, they pulled back to Arkansas. That need to be taught into the schools. Can I ask of you gentlemen, if you're going to do a panel, would you please include us, the black Indians that's not on reservations, have never been on reservation, but have struggled to survive amidst all the other ethnic groups here. And by the grace of God, even that flood in Louisiana still have not wiped us out.
Thank you for sharing that. I've actually been in touch with some African Americans who also are Native Americans in the state of Oklahoma. And they've been encountering some of the very same problems, serious problems. I can't tell you what will happen. I just would tell you to stay tuned. It is taken on a very different level of significance. And before the year is out, you'll be hearing more about that.
When I was chased out of Little Rock in 1958, I was thrown into the proverbial briar patch with Kenneth and Mamie Clark. I lived in their home.
Would you tell, not everyone know who this wonderful woman of the Little Rock Nine is?
No,
some people don't know.
about who Kenneth and Mamie Clark.
I know, but some people need to know who you are.
I'm the sister of Bobby Brown, social justice advocate in Little Rock, Arkansas.
There you go.
Okay, that'll. No. But Dr. Mamie Clark, who did considerable work on identity, self-identity, especially among black children, died in the late 80s. And Dr. Kenneth Clark said that she died disappointed that what they dreamed and the work they'd done did not come to pass. And then Dr. Clark died earlier this year. You know, are you also, Judge Carter, disappointed that what you worked hard for a whole lifetime did not come to pass.
Are you disappointed what you worked for your whole lifetime has not come to pass? How do you feel about where we are? Her question was that, you know, that both Clarks died feeling sort of disappointed that things have not changed and people have not embraced what they were doing 50 years ago. How do you feel?
I know. I'm not sure that I'm an optimist sometimes. You know, fatuous, I guess I am. And I have Charles and several other people that are carrying on the struggle. And I'm not one of those people who feels that everything in the past is all that's good. I think things are going to be better, and that the future is in this man's hands, and some people like him, and I'm very happy with that.
Go back over to this side, please.
He's bringing a microphone for you. To your left. I think they're recording it.
We have in Arkansas a number of either predominantly or all black colleges. And the question that some of us have struggled with for a long time, is it better to work to integrate those colleges or to support them as they are now, as all black institutions?
Judge Carter may have his own response, but my response is simply this. What's remarkable about the HBCUs is that they've never discriminated against anyone who's not black. That is, they're open institutions, they're public institutions. And the reality is that many people make assumptions about them that are wrong. I mean, think of what kind of education you would have received as a white lawyer in the 1930s at Howard Law School with Charles Hamilton Houston as the dean and with Thurgood Marshall and Oliver Hill as your classmates. You could not have received a better education in America. Why? Because whether it's Harvard or Yale or Stanford, there's no law school that produced any sort of legal geniuses to change our Supreme Court's decisions the way that they did. It's not like the court changed all of a sudden from conservative to liberal. It was the same court. It was better arguments by well-prepared lawyers that made a difference. So that's one of the values of an HBCU, that it's open. And the question that you pose, in my view, is not a contradiction. You want to do both. You want to integrate HBCUs and support them for what they are. Because today, remarkably, with the kickbacks and the setbacks and the reaction to affirmative action, HBCUs are the only resort for many African Americans who are trying to get an initial education. And the irony of it, I have to tell this story. There are 1,000 stories like this, and I heard this one when I was at the Just the Beginning conference last year in October. There's an organization of black federal judges called Just the Beginning. There are countless African American black federal judges who are from the South, who could not go to school in the South, who had to go elsewhere. There's one who went to Miles College in Alabama, and he wanted to go to the University of Alabama to law school. He would not be admitted. They sent that judge, you know what I'm talking about, they sent him to Columbia. He went to Columbia Law School, got a first-rate education at Columbia Law School, came back and sued to integrate the University of Alabama Law School, right? And so it tells you over and over again that's what's happening. So I don't think there's a dilemma there. I think you need to start making our children realize that they should get a good education. What's great about these HBCUs is that in terms of race, it's largely irrelevant. What do I mean by that? You can't say, I got a C because the professor discriminated. You can't say, I'm not learning because the professor doesn't like me. You can't use race as a crutch in getting a quality education. It is an equalizer where you don't use it as a crutch or as a barrier in HBCUs, and they are so important and so significant. And I think when you think of, I don't know if the president of Philander Smith is here or not, but when you start thinking, all right, if you think about these schools, they are educating, I don't know how many, but I mean, first generation. Many of us talk about, I'm the fifth in my family to go to so-and-so. Today, we're still finding these schools where these young people are the first ever to go to college. Not 1950, 1970, but 2005, their mothers and aunts and uncles and grandparents did not go to college. And what's really remarkable, this is an issue as much of class as it is of race. There are a lot of poor folks who are the first to go to college. That's our problem. It's not race, it's as much class as it is race. And I would say the idea is not to ignore the HBCUs, but to see the role that they play and to find other ways to encourage students to go there to get good educations, because it should not be exclusive. It's only exclusive because they couldn't go anywhere before, but now they really are the places where people can go. And a number of them are majority white now. Bluefield in West Virginia. There are several of them that have changed. They're called HBCUs, but they're majority white students and 21st students. Judge Carter, you want to respond to that? HBCUs?
Well, I don't think you can have your cake and eat it too. And my feeling is that these institutions, if the universities become integrated, that these institutions have to become a part of that. But what seems to happen is in many places where they do, they disappear. And they become all white, and these institutions disappear. It seems to me that what integration must mean is that there's representation of both of the groups. So that you just can't get rid of them, get rid of all the black teachers and so forth and so on. It has to be real integration. And that is what a university has to do, it seems to me.
We've got time for one more question. I think there was someone over here.
We've got time for two more questions.
Two more questions.
I'm Doris Elliott from here in Little Rock, and I always notice that civil rights will kind of make the room tight and people shift in their seats and whatnot, because it seems to be such an unpopular subject today. I mean, whether it's about the autonomy to do what I want with my body, or whether or not we're talking about gay rights or women's rights or whatever. And what seems to me to be the case is that, and you need to either maybe affirm or disabuse me of this notion, but there seems to be a dearth of lawyers who are interested or who will step up to the plate for civil rights these days. And I would like to hear your comments on whether that's the case or not, please.
The simple answer is that is the case. And in some sense, our legal institutions can either get the praise or the blame. I don't think I'm different. I've changed as a law professor. Our philosophy is that we teach students how to think and not what to think. That's an important distinction. That is, we teach you how to think, and you figure out what you want to do once you learn those skills. That's a very important degree of neutrality. We'll give you all the tools. We don't care which side you represent. You'll be facile on both sides. You choose. And there are two problems. The jobs aren't as desirable as we've created them, because you can make our students, Harvard law students, make more, with all due respect to all these federal judges, right? They start off at a law firm making more than a judge who's practiced for 10 or 20 or 30 years, incredible experience, and they run for that money. That's number one. That's one of the disincentives. The other disincentive is that the great civil rights organizations can't hire you. They really can't. The NAACP, Legal Defense and Education Fund, would love to have the best and the brightest, but they can't expand their legal team because all of their people are supported by soft money. That is, that they don't have multi-million-dollar accounts where they can just add 2 or 3 more lawyers. They can't hire any lawyers out of law school. They really can't. They need someone who can walk right into Arkansas or Pennsylvania or California and bring a major federal or state case tomorrow. And so that's another disincentive. You can't get the job, the prize jobs. But that doesn't mean people can't be civil rights lawyers. There's a whole lot of civil rights. You can work for your local district attorney. You can work for your local city attorney. You can work for a corporation counsel. You can work for a whole series of places and have an impact on the system. And what we need to do, we forget the first civil rights class ever taught in the history of America was taught at Howard Law School. I mean, think about that. People never even thought about it as a field, and it was taught by Jim Nabrett, Northwestern law graduate, I think, who taught at Howard Law School in the 1930s, the first civil rights course. And now it's an option, and we don't even teach our students in constitutional law. They'll learn the Commerce Clause, right? Haven't you all learned the Commerce Clause, right? But how much they've learned about the civil rights movement is very hard. It's not a high priority. So I think transforming what we see as priorities in legal teaching is important. Let me tell you one that's happened at Harvard that I think is happening national. We're going to start requiring every student at Harvard who graduates to take a course in international law, because we've finally realized, that the world is a global legal community, and that we can't be so regionally chauvinistic that we can't see the importance of what happens in Venezuela and in Europe and in Asia having an impact on what happens in Peoria and in Little Rock. It really does. Whether it's commerce, whether it's issues of custody, whether it's issues of capital punishment, a whole series of issues, international law. It seems to me civil rights, which is a very broad concept, is the same kind of course that we need to rethink of how it impacts everyone. What we've forgotten is that these lawyers won the Brown case, but because of Brown, we were able to have policies that impacted other groups like women. Gender rights substantially changed. The rights of immigrants changed dramatically. The rights of the physically impaired changed because of civil rights. The rights of the mentally impaired changed because of civil rights. All of the sort of rights that we have a base with the Brown decision, and people start saying equality, that has nothing to do with just race. It has to do with every concept of law imaginable. And now judges are asked every single day to think of every kind of right that emanates from civil rights, and it really is a universal principle, and you're right, you've identified, these judges will tell you they've got all kinds of cases. Race cases are probably the rarest, but every kind of right, whether it's disability or mental health or whatever, is now part of the spectrum of rights. And we just need to make sure it's an issue that's, again, in the public domain. And we need to hear you in the legal academy to train our students, our future lawyers, to understand that to be a good lawyer, you need to understand the idea of civility and rights and responsibilities in law, and not just transactional issues, not just commercial issues, but all the other aspects of law, and you've hit it right on the nail.
We really do have time just for one more question here.
Good evening. I'm David Briscoe, professor of sociology at the University of Arkansas, Little Rock. To both of you scholars, it appears very ominous that race is a national issue in this country. It has been for a very long time, and it probably will continue in the future. You speak of it as being a national issue. Could you speak to how we might go about solving this thing, or at least managing racism in this country from a national perspective?
How you go about solving this national problem of racism from a national perspective?
Here's my view, is that it takes national leadership. I mean, it really takes national leadership. And it doesn't have to be it needs to be a democratic form of government, but it doesn't require a Democrat for that to happen, if you understand what I'm saying. That anyone who embraces the principles can understand the importance of national leadership. And it means that we have to think about our responsibilities in terms of the media. I just got on my email from a first week law student at Georgetown Law Center, an African-American student. He sent me 2 photographs from the national press. One, this is from Louisiana, it was saying blacks are looting as a result of the hurricane. The second photograph had a young white woman, a young white man, saying Sarah and Bob are able to get to safety because they were able to find some food from a local store because their homes have been washed away, right? And I mean, it's amazing because you think of what messages that sends. The looting, you watch looting, you watch it, you will never see white looters, right? It just doesn't, I mean, it doesn't capture the imagination of the photographer, right? And so that tells me that it reinforces everything negative about one group and everything positive about another group, and that's why it's a national phenomenon. And the other part of it is, I think it's not just national, but it is personal. I can walk around this place or any institution as long as I'm down, you know, dressed like this. But when I'm jogging, whether it's in Washington, D.C. or in Cambridge, Massachusetts, wherever, it's a different profile. And I said, why am I out here jogging with my ID? Because you never leave home without it. Right? That's the problem. And it's not a white police officer. It doesn't matter who's the officer. Those perceptions about race are personal. They're personal. They're not institutional. They're personal. And until we can get our children to think about it differently, we're going to have this problem. But I say national is important, but I really do think that until we can have a dialogue, it's going to be very important. And let me just say this final thing, since this is my last opportunity to speak. I really do urge more white citizens to talk about issues of race. It's uncomfortable. It's awkward. You're worried about being labeled a racist. But we can't go forward without having a meaningful dialogue from everyone. Justice Harry Blackmun said it in the Bakke case. Go back and read his concurring opinion. He said, I yield to no one in my idea to have a race-free society. I don't want to have the recognition of race as part of the way we live. But he says, in order to get beyond race, we have to deal with racism. There is no other way. Right? We can't ignore it. We can't belittle it. We have to deal with it. And if we don't deal with it, as he did in that opinion, a wonderful opinion in Bakke, honestly, then we won't make any progress. And so I urge folks to, it may seem uncomfortable, it may seem, just tell the truth. When you're walking in the garage and you see someone walking behind you, get uncomfortable? Of course you do. Right? When you see someone coming into the office, you assume that they're a messenger rather than a partner in the law firm. That's America. But we have to have the dialogue in order to make any progress. And I know I'm going to be talking to folks. I know I'm going to hear it, but I need to hear other folks who are sitting there silently wondering, this is not a conversation about race, this is really a conversation about America and equality. And if we can't have that conversation, we'll be here again on the 50th anniversary of the Little Rock Nine, wondering why the black kids are sitting together in the cafeteria around one table. It's because we haven't dealt with race. If you don't deal with it, you can't get beyond it. Clear and simple.
I don't know how many of you were old enough to have been around when President Johnson was in the White House. If you were, you will recall he was a man who dedicated himself to solve this problem on a national level. First and only president has done that. But he had too much husband, or whatever you call it, being from Texas. He thought that he could handle this problem, fight in Vietnam, and so forth. And what occurred, of course, was that the issue that he had started out with as a Southerner, committed to using the president's office to solve this issue of race in the country and push for it, and was lost with the Vietnam War. It was a very tragic thing. But if he hadn't had all the Texas, whatever it is, the husband, if he hadn't had that, we might have been much further along towards getting that problem solved than we are today.
Before I ask Dean Pryor, one of my deans, to come up here today. I'd just like to have you join me in thanking these remarkable men.
And John, we want to thank you very, very much. You did a wonderful job at moderating. First, we have copies of Judge Carter's book, which is A Matter of Law, is wonderful. We have All Deliberate Speed by Charles Ogletree, Jr. It is also wonderful and very, very informative, as are both of these books. If you go out of the library and go toward the Choctaw, how did you say it? We say Choctaw, I don't know. Okay. If you go toward the red, as we call it, the little red schoolhouse over here, please note that there will be a little desk there, and there you can purchase your books. Now you can go inside and get the books signed after you purchase them outside. One of these days, are there any lawyers in the room? I'd like to talk to you about that, but we won't go into that now. Okay. The second thing is this little blue card right here. I know this is the computer age and the age of information. This is our database right here. We want you to fill it out. We want to know who you are. We want to know what you want to see, what you want to hear. And I can tell you there's not going to be many nights that are going to surpass what we've just had here tonight. But we're going to do our very, very best to have some wonderful programs for you. Please fill that card out. You'll see some boxes out there. Our students, our inaugural student body, and our faculty and our staff, they have made available 2 or 3 boxes out there in case. We're not soliciting, but in case some of you might like to give a little cash or write a little check to the American Red Cross. And this money will be distributed to those in need who have been victims of the recent hurricane and the flood in the South. The next announcement is just about the last. Refreshments are going to be served downstairs in Cafe 42. And I think that is just about it, except I did not recognize Rodney Slater, our wonderful dignitary here tonight, our former Secretary of Transportation. Rodney, thank you very much. Nor did I recognize our friend and a member of our local advisory executive committee, the Honorable Ollie Neal. Judge Neal, we're proud that you're here with us this evening. And our 2 chancellors, Chancellor Joel Anderson, UALR, Chancellor Dodd Wilson from UAMS, who are our partners in the Clinton School of Public Service. We want you to know we revere that partnership. We thank you so much for your wonderful support. Well, ladies and gentlemen, that is what this is all about. We want debate and discussion, exchange of thoughts and ideas. And Professor Ogletree, we do want to talk about those issues which are American issues. And you and Judge Carter have graced our school and our library, and we want you to know that we will always be very, very indebted to the 2 of you for making the effort, for being here and sharing your great wisdom and thoughts with us. So, ladies and gentlemen, with that, we bid you a fond farewell. We look forward to our next venture with you. Thank you very, very much.